For Creamer Media's Polity, I'm Tabi Shomulikai, Director of Land Reform Act, Werksmans Attorneys. Bulelwa Mabasa joins me to unpack the Expropriation Act. Welcome, Bulelwa.
Thank you very much. It's wonderful to be with you.
So last month, President Cyril Ramaphosa signed into law the controversial expropriation bill, which set out how the state can expropriate land in the public interest. But the bill has been met with criticism and concerns, particularly the section that set out compensation with nil compensation. So, is there a legitimate cause for concern on this point? And can you briefly explain the conditions under which expropriation without compensation is provided for in the Act?
Yes, I think the first premise that we need to start from is firstly where expropriation comes from. Expropriation, the old 75 Act that we had was in operation for 50 years. But then when the democratic government came in and our constitution was promulgated in 1996, which was about 29 years ago, it also allowed for expropriation. That's our constitution. However, our constitution makes provision for compensation that is just and equitable. In other words, our constitution makes provision for expropriation to happen. However, the amount of compensation that is payable may sometimes be less or more than market value. Whereas the old 1975 Act, which was used by the apartheid government and also by the post-democratic government, used a system of willing buyer, willing seller. Willing buyer, willing seller simply means that when government was purchasing land or property, the property owner could simply present a market valuation. And that was the basis of the compensation that was going to be given. Now, the section that you're asking about, which is a section of expropriation without compensation, the argument that has been raised about that is that the Constitution makes expropriation inextricably linked with compensation. So the argument there is that in South Africa, we don't have a system that allows for expropriation without compensation. Those instances that allow for expropriation without compensation are things like unused buildings, unused land, where the landowner has abandoned the land, and also where the state holds property or assets, where, for example, the state doesn't require to hold such assets and property in order to deliver on service delivery. So there's two arguments. So when you look at the Constitution, as I said, it allows for expropriation with just and equitable compensation. It says you must look at the current use of the property. So what is the property being used for? If the property doesn't have a use, you go to the next step. What is the market value of the property? If the land or the property owes rates and taxes more than its market value, already that's going to give you zero. You move to the next step and you say, how was the property acquired? If the property or land was a donation, for example, from the state, well, then nobody needs to be paid. You move to the next step. Was there any direct state investment? And you move to that step. So already it shows you that even within Section 25(3) of the Constitution of just and equitable compensation, it is possible that certain instances may lead to zero compensation. It's not going to be many of them because most things will have its use, they'll have a market value and so forth. So when you look at those considerations, then you come to the conclusion that if a building is unused, the owner is not there, it's abandoned, it provides safety and health risks. It's not difficult to see that even if you apply the just and equitable format, you may still result in nil compensation. So that is really the argument out there. The one is, well, why do you need to put this in the Act if the Constitution already makes provision for it? There are two answers to that. Firstly, it is to allay the fears of investors, to say that if you have an investment in South Africa, there's productive use, it's being used, there's job creation. Clearly, that's not going to be brought in within the expropriation without compensation format. Others will say, so it is actually a welcome thing to then have Section 12(3) that tells you exactly what circumstances will attract expropriation without compensation.
Then, what is the purpose of the Act and how does this law help South Africa?
The purpose of the Act, Tabby, is actually quite benign. It's actually more about state administration. What that means is that most governments, if not all governments in the world, including in America, have an expropriation law. In America, they can call it eminent domain. It can be called anything else anywhere else. And most developed nations have an expropriation in order to allow the state to be able to purchase land or property for the public good. It's there in order to ensure that the states can run its normal business. It can secure land to build a bridge for the Gautrain, for public schools, for public clinics, for public libraries, because it's understood that the state is not always going to have sufficient land by itself. So it will need to purchase the land from a private owner. So expropriation as a concept, we've had it in South Africa since time immemorial. We've had it through the apartheid government. We've even had it before the apartheid government. And in that case, that was expropriation without compensation. But here, this act is actually an act that promotes just and equitable compensation. It only provides for nil compensation in very pointed circumstances and instances.
And when must compensation be paid? For example, if the land that is expropriated in order to make way for electricity transmission lines for a new road. Also, does the Act outline that the level of compensation will be calculated?
Yes, it does include the format of the Constitution, as I said. And actually, the process to expropriate in this particular new act is very laborious and it's going to be time consuming. It's actually made it more difficult for the state to expropriate because of all the steps that the state must take. It needs to first send a notice to intention of expropriation. It then needs to ensure that they have reports from many different government departments, from the Department of Land Reform, from the Department of Electricity, from the Department of Environment. So that already tells you that there are many hoops that the state has to go through in order to pass with just, justifying why an expropriation must happen. Then there's another element, there's another stage of offering an amount of compensation. And even then, a landowner or private owner has an opportunity to object. They have an opportunity to go through mediation. They have an opportunity to go arbitration. And ultimately, the courts, when there is no agreement, are the ones that are going to make a determination on the amount of compensation. So there is a section that may be controversial in the Act, if I'm not mistaken, that says that an expropriation can continue while all of these processes occur, and that the compensation may be paid afterwards, where, for example, the state has made cogent reasons why it needs an urgent expropriation.
And can you tell us the difference between the two justifications of the expropriation for a public purpose and in the public interest?
The Expropriation Act of 1975 was always made provision for expropriation in the public purpose. Public purpose are things like building a bridge. The Gautrain was a public purpose. Electricity transmission lines would be a public purpose. Public interest in the Constitution tells us that will include things like the nation's commitment to land reform. So in other words, whereas the government was able to purchase this land for, providing electricity lines and for power stations and that sort of thing, now they are also specifically allowed to do so in order to make way for citizens that need land for land reform purposes as well. So that is the distinction between public interest and public purpose.
And does the Act offer any protection to prevent possible corruption by expropriating authorities?
Look, I think corruption happens where you find that there is political will for corruption to happen. But in the way of reading the Act, as I said, there's so many steps and hoops that the state needs to follow in expropriating, even a higher burden than it was in the old Act. So it remains to be seen whether or not corruption can creep in. But I think what's important and for the nation to realize is that actually the state now has a higher burden of proving and justifying why an expropriation is necessary because the act is drafted in such in a hugely administrative and burdensome way.
And lastly, Bulelwa, the Democratic Alliance has filed court papers in the Western Cape High Court last week to challenge the act. So what is the basics of the DA's challenge to the law?
Interestingly, the DA's challenge is mainly based on procedural issues. They have raised mandates that were required in each of their provinces in the National Council of Provinces, and they have said that there weren't the procedurally those provinces did not meet the necessary requirements of passing a law in the NCOP. Now, those are very much procedural issues. Interestingly for me, I would have thought that the DA would have raised more substantive issues with the act, such as expropriation without compensation provisions, and maybe even the burden that is placed on, the finalization of the amount of compensation. But so I felt that it was a missed opportunity. If there are any constitutional issues to have been raised, I think those needed to have been substantive issues rather than procedural issues. But of course, there is also the argument that procedural law is also necessary in order to reach a substantive conclusion on whether something is lawful or not. But I think it's safe to say that the DA challenge doesn't really go far enough in challenging the actual substance of the act.
That was Bulelwa Mabasa speaking to Creamer Media's Polity about the Expropriation Act.